Welcome to the lecture on law and motions. This lecture is the first of two lectures on that part of litigation practice that involves motions. And in this lecture, we're going to get a basic idea of what motions are. In the following lecture, we're going to look at a sampling of some of the more commonly filed types of motions. So to get started, let's understand some basic terminology about motions in litigation practice. A motion is a party's written or oral application to a court for an order. Again, the order itself is the court's ruling on that motion. The party filing the motion is called the movant, and the party that is not filing the motion, but rather responding to another party's motion, is the non-movant. Now, the whole process of preparing and filing a motion or responding to a motion, as well as attending any hearing on a motion and preparing a proposed order for the judge to sign with respect to a motion, are all part and parcel of what is called motion practice. In addition to the motion, normally a party will also attach what's called a memorandum of law. And that is a brief in support of the motion that will set forth background facts, will cite to legal authorities, and will present arguments in support of the motion. Now, if you are a party opposing a motion, then you very well might file a response in opposition, in which case you might attach a memorandum of law that would argue against the motion. Now, motions frequently have evidence attached to them. And one common form of evidence attached to motions is the affidavit. That is a written statement made by a witness, made under oath and acknowledged by a notary public. Now, in federal practice, there is a similar document to an affidavit called a declaration. That too is a written statement signed by a witness. However, that witness has not been placed under oath and it is not acknowledged by a notary public. Nevertheless, that statement is made subject to the penalty of perjury. So whereas affidavits are sworn, that is, they're made under oath and acknowledged by a notary public, declarations are not, but the person who signed it is nevertheless subject to the penalty of perjury if it turns out there were misstatements of fact in it. Now, the purposes of motions really are twofold. First is to regulate routine housekeeping matters in litigation. For example, a party or both parties may decide they need more time to complete the discovery process than the court's scheduling order allows. Or a party may want additional time to accomplish a deposition. Or the parties may have been ordered by the court to participate in mediation. And because of scheduling problems, they want the court to extend the deadline for doing that. So if so, one or both of the parties may file a motion asking the court to extend the time. One very common type of motion has to do with discovery. If one party sends a discovery request, such as interrogatories or a request for production of documents to another party, and the other party either does not respond at all or sends back unmeritorious objections, then the requesting party may file a motion to compel the responding party to respond properly to those requests. And sometimes the parties may have a trial setting looming, but for whatever reason, they would like the court to extend that deadline or the trial date. And so they will file a motion asking the court to continue the trial. And that is a common type of motion as well. So in addition to these housekeeping matters in litigation, sometimes a party may actually file a motion called a dispositive motion. That is a motion that is asking the court, on the basis of the motion, to dispose of the entire case. That is, if you're a defendant, to throw the case out completely, or at least certain causes of action that have been asserted. Or if you're a plaintiff, you may ask the court to throw out certain defenses that the defendant has pleaded. These are called dispositive motions because they dispose of the entire case or at least certain causes of action in the case. So sometimes a party may ask the court to dismiss the case completely because the court lacks jurisdiction. In addition, a party may believe that the facts that entitle that party to win the case, once those facts are applied to the law, are undisputed, either because the opposing party has admitted them in discovery or there is no evidence to contradict those facts, in which case that party would file a motion for summary judgment, asking the court to grant summary judgment, ruling essentially that the moving party wins the case. Now let's talk about specifically what a motion should look like and what information it must contain generally. That would be the form and substance. So let's start with the form. Under the Federal Rules of Civil Procedure, a motion must be in writing unless it is made in open court during a hearing or trial. In addition, the motion must state with particularity the grounds, that is, the reasons for seeking whatever order it is the party wants from the court. And finally, of course, the moving party has to state what it is the court is supposed to order. And this is Rule 7, subsection B, subsection 1 of the Federal Rules of Civil Procedure. Now, the rules that govern captions to court documents and other matters of form, such as the signature blocks or subscriptions in pleadings, will also apply to motions. So a lot of the format that you will see in pleadings also applies to motions. Now, in addition to the Federal Rules of Civil Procedure, every district court has its own local rules, and those local rules very well might provide additional requirements or restrictions on how motions should be formed, how should they should be crafted and submitted. So you need to be sure to consult both the local rules and any specific requirements by your specific judge to make sure that you are submitting motions in the proper format for that particular court and that particular judge. Many local rules provide basic guidelines such as page limits for motions. Some require a minimum font size, such as 12 point. Some require that motions contain footers, that is, each page of the motion has to have a statement at the bottom that indicates the page number of each page. And some courts will require that the memorandum of law supporting the motion must be filed with the motion. And sometimes the court will say they have to be filed as separate documents, and other courts will require that they be combined into one document. In addition, many courts will require that evidence supporting the motion, such as affidavits or other pertinent documents that are not already on file with the court, be attached directly to the motion. And one very common local rule requirement or judge's requirement is that the moving party, in addition to filing the motion, must submit a proposed draft order along with the motion so that the judge can look at the order and know exactly the relief that the moving party would like to see in the order. That's just a proposed order. That doesn't mean the judge has to sign it, but the judge normally likes to see what the moving party would, if the motion were fully granted, like to see in the order. In addition, some local rules or judges' requirements will require that in addition to the motion actually filed with the clerk of the court, whether it is by electronic filing or traditional paper filing, must also involve submitting an extra paper copy directly to the judge's chambers. This is called a judge's copy. It's simply an extra paper copy of the motion, the brief, the evidence, and proposed order, so that the judge himself or herself may have his or her personal copy of it, may make notes on it for use at or prior to or at the hearing. In addition, most local rules also require that motions contain a certificate of conference. A certificate of conference is a little paragraph that certifies to the court and signed by the filing attorney or by a party if that party is not represented by an attorney, stating that the attorneys or parties have already discussed with each other the substance of the motion and that they could not reach an agreement on it, and that is why filing the motion and perhaps having a hearing, if the court will do that, is necessary. Courts do not like to receive motions from parties and be dragged into a matter that could easily have been resolved if the parties had simply talked with each other and tried to work it out ahead of time. This is the certificate of conference requirement. It is normally required in discovery related motions, and many local rules require it for many other types of motions too. So you will want to be sure to check the local rules and the judge's requirements for those types of motions. Sometimes courts do not require certificates of conference for dispositive motions because normally you can't get the other side to agree that that party's case should be thrown out. So that's the basic form. Now let's look at the substance of a motion. Now again, subject to the local rules and any judge's requirements, a person who or party who moves for relief from the court has great flexibility with regard to what is stated in the motion and how long it is. And that will depend on the nature of the motion and how complex the issues are involved in the motion. Now, normally within the motion itself, you will have simply a short document describing the relief requested. That is, the motion itself is a document simply announcing to the court that it is asking the court to do something and specifying what that is. So the motion itself is frequently very short. Now, what is usually not quite so short is the memorandum of law, also known as the brief in support of the motion. It will be lengthier because it will detail background facts for the judge's benefit, facts that are relevant to the issue the judge is asked to be ruling on. It will cite legal authority, case law, statutes, and the like that support the party's arguments for why it's entitled to the order it's asking for. And again, this memorandum of law, depending on local rules, may be required to be a separate document from the brief motion, or it may be required to be combined with the motion itself into one document. So that will again be another reason you need to check the local rules and the judge's requirements. In addition to the motion itself and the memorandum of law, finally, if the motion is dependent upon facts that are not already filed, based in evidence filed with the court, already filed in documents that are already in the court's official file, then the moving party will need to file that evidence that support those facts. Normally they're affidavits, but they may also be another party's responses to written discovery requests. It could be excerpts from deposition transcripts or any other documents that support and evidence the facts that the moving party is relying upon in seeking the order it's asking for. Now, here's an example of a certificate of conference requirement. As I've just mentioned, the certificate of conference, sometimes known as a certificate of compliance, is a written statement by the lawyer, often required by local rules, certifying that the lawyer has attempted to meet in good faith with the opposing party to resolve the subject of the motion, and that that attempt was unsuccessful, and that the motion and possibly a hearing will therefore be necessary. Now, sometimes the local rules will actually specify exactly how these certificates of conference should be written. Here is an example of a local rule from the Eastern District of Texas. Local Rule CV7 subsection I relates to certificates of conference. And as you can see here, the rule requires that there be various details stated in the certificate of conference. So it shall include a statement signed by the movant's attorney that the personal conference or conferences required by the local rule have been conducted or were attempted, the date and manner of such conferences, such as were they over the telephone, were they in person, and the names of the participants in the conferences, and an explanation of why no agreement could be reached, and a statement that discussions have conclusively ended in an impasse, leaving an open issue for the court to resolve. So the Eastern District of Texas is very specific about the information that a certificate of conference must contain. If you do not comply with the local rules about certificates of conference, the court may refuse to consider the motion. Now, another certificate that's very much in the same type of format as a certificate of conference is the certificate of service, sometimes known as proof of service. This normally goes after the certificate of conference, and it is a written statement signed by the lawyer at the end of a motion or any other court filing, certifying the particulars relating to that lawyer's forwarding a copy of whatever this document is that's being filed to all other attorneys of record, as well as to any other unrepresented parties who have appeared in the case. Now, local rules normally also require these certificates on all court filings. And some local rules actually will specify the exact wording or information these certificates must contain. So again, you need to be sure that you are checking those rules to be sure you're complying with them. So here's an example motion. This will be a motion to extend time to mediate. So you can see here on the first page that at the top it has a caption just the way pleadings do. It's the same official caption for the lawsuit. And then it has a title of the document. And as we've seen before, the title of a court document needs to contain 3 pieces of information: the identity of the party filing it, the version of the document, if it's the type of document that might be later amended, and then finally, the type of document. Well, here in our title, we've identified who is filing the motion. It's the plaintiff. Since there's only one plaintiff, you can just say plaintiff's motion to extend time to mediate. Now, motions sometimes are amended, but it is not a frequent occurrence as you see with amending pleadings. So normally a party filing a motion will not call it the original motion to extend time. Instead, it will simply call it motion to extend time to mediate. Now, if a subsequent motion is filed, or if this motion is amended or modified, then it would be called plaintiff's first amended motion to extend time to mediate. So this is an example of where you really don't need the version specified in the title. And then finally, we have the type of document. It is a motion to extend time to mediate. So basically the same format for a pleading, and you have numbered paragraphs, and this is the motion, so it's going to be short. It is simply in very concise language announcing that the movement wants the court to extend the deadline for the parties to mediate. And then at the end, here's the certificate of conference to comply with the local rules. And then finally, the certificate of service indicating when and how a copy of this document was served on the other lawyer in the case. And here we have the signature block, also known as the subscription. And in this version, we have the electronic signature typed in, which is the way it is required to be done in the Eastern District of Texas if a party is going to electronically file the motion rather than file it on paper. So that's an example of the motion itself. The motion, again, is normally very brief. Now let's look at an example of a memorandum of law that would be filed with it to support the motion. These are a little bit more involved. Now the basic format starts off pretty much the way we started off the motion. You have the caption, you have the title of the document, and here it's plaintiff's memorandum in support of motion to extend time. Now on the second screen here, you see that normally the moving party will provide some background facts so the judge has some context of the case. So the first paragraph here informs the judge or reminds the judge what this case is about. It's about an automobile accident for personal injury, case for personal injury. And then the second paragraph refers to the court's previous order imposing a mediation deadline of April 30th, 2017. And then it also says that the moving party filed this motion to extend time as soon as he became aware of the need for additional time and before the deadline has passed. After that, you've got some authorities cited here. You have the Federal Rules of Civil Procedure and a Ninth Circuit Court of Appeals opinion. And that is to support the proposition that a court may grant a request to extend time for good cause. That means good reason. And so paragraph 5 then goes on to argue what the good reason for extending the time is. And it has to do with the plaintiff's having suffered a heart attack resulting in his hospitalization. And you will see here that there are footnotes that can point the court to the actual evidence file with the motion supporting each of the facts that the moving party is relying on here. And so that's a good thing to do. I recommend that you do that. Some local rules may require that so that if the judge wants to verify that there is evidence on file to support these facts, the judge will know exactly where to go. Here, it would be an affidavit of Buford T. Justice attached to the memorandum as Exhibit A, and then there's also an affidavit of a doctor, which is attached to the memorandum as Exhibit B. And so this is the way the memorandum goes forward. And it simply gives background facts, cites to key facts that are necessary to support the argument for why the relief requested should be granted. It cites to appropriate legal authorities and concludes. And so here we have finally the certificate of service showing that a copy of this memorandum has been sent to opposing counsel. You do not need another certificate of conference because you've already put that in the motion part, and so you don't need to repeat that in the memorandum of law. Although you can if you want to, but it's not required as long as it appears in the motion. And then here is the signature block or subscription, and that is the brief example of a memorandum of law in support of a motion. Well, now let's talk about what happens once you've got the motion and the memorandum of law and all your evidence prepared. The first thing to do is to file it. Now, the local rules and sometimes judges' requirements will prescribe the manner in which the parties must file court documents. Many federal courts, if not most, will require parties who are represented by attorneys to electronically file their documents. But you may have a judge or a particular, especially you might have a judge that wants things paper filed instead. So you need, again, to look at the local rules and the judge's requirements to be sure you're doing exactly what is required for your particular court and judge. Now, sometimes if the judge allows or the court allows e-filing or requires e-filing, the local rules or judges' requirements might specify that the motion itself and the memorandum of law and the supporting evidence be attached online as separate PDF documents rather than one big combined PDF document. So you need to be aware of the requirements in that regard. In addition, if you're filing evidence, like if you have a bunch of documents that you're wanting to support your motion with, some courts will require that they be consecutively numbered at the bottom. which is if you use a bait stamp, which is kind of traditionally a rubber stamp that you use where the page number automatically advances, and you just very quickly rubber stamp all of the pages at the bottom, so they'll be consecutively page numbered. Now you have computer programs that do that. You can print out labels, but sometimes courts require that. It's called Bates labeling. And some courts require that the evidence have an index on top and be tabbed so that the judge can flip to the exact piece of evidence without having to wade through it all to find it. So again, just be sure that you are putting together your motion the way the local rules and judges' requirements mandate. Now, one very frequent requirement, as I mentioned earlier, is that in federal courts, frequently the judges will require the moving party to submit a proposed draft order that party would like the judge to sign if the judge grants the motion. Now, how you submit that will vary from court to court and judge to judge. Some judges will ask that you file it. Other judges will simply ask that you submit it separately to the judges' chambers. And some judges have special email addresses solely for the purpose of parties to file proposed draft orders on motions, and that way they don't get mixed up with other court documents. So yet again, I know I sound like a broken record, but be sure to check the local rules and judges' requirements for proposed draft orders in connection with a pending motion. Now, some judges may also require that, as I mentioned earlier, that an entire paper extra copy of the motion, the memo, the evidence, the proposed order, all be submitted to the judge's chambers for the judge's own personal use. That judge's copy is often a requirement, so be sure to check for that also. Now, once you've got it on file, one thing to know about federal courts is that unlike state court judges in Texas, federal court judges normally hear routine motions on submission, unless either the judge wants to have an oral hearing and requires it, or one of the parties requests an oral hearing. Now, for a judge to consider a motion on submission means that the judge is simply going to look at the filings of the parties, that is, the paper, what the parties actually filed with the court in connection. They will not, the judges will not have an oral hearing where witnesses will be called live and the attorneys will argue live. Instead, the parties will just be expected to make their full arguments and have all their evidence on paper and properly filed. And the judge will read these materials and then issue a ruling. Now, it depends on the local rules or judges' requirements whether or not certain types of motions are even allowed to have hearings, or they may require that certain types of motions require hearings. So again, you'll just have to check the local rules to be sure there. Now, if a party wants the court to hold an oral hearing, normally the party will have to specifically request that hearing in federal court. And the local rules or the judge's requirements will specify the protocol for how to do that. So here's an example of the Eastern Districts of Texas local rule that relates to oral hearings. As you can see, local rule CV7, subsection G, says that a party may, in a motion or in that party's response to a motion, specifically request an oral hearing. But whether or not the judge will allow an oral hearing will be within the sole discretion of the judge. So in the Eastern District, you can certainly request a hearing, but the judge is by no means required to grant it. The judge has discretion on that issue. Other local rules may require that a party who wants an oral hearing to contact the court clerk or the administrator of the court after filing the motion to obtain available dates and times on the court's hearing docket. And many require that once you've done that, you then have to contact the opposing attorney to make sure that attorney would be available on one or more of those dates, and if so, to contact the court clerk back to confirm, either orally or in writing, the date and time of the hearing to take place. So again, it just varies from court to court, the procedures you would need to use to set an oral hearing. But one thing you need to do if you do set an oral hearing, you need to set it sufficiently ahead of time. In other words, you need to be able to set the hearing date far enough in advance so that you can give the opposing party sufficient notice of the hearing as required by the rules of civil procedure or the local rules or judges requirements. Now, some types of motions and in federal practice, especially if they're routine or if they deal with discovery, which judges hate to deal with, many times are delegated to a person called a U.S. magistrate instead of the U.S. district judge himself or herself. A U.S. magistrate is an officer of the court who by statute is authorized to hear routine civil pretrial matters. So you may have a hearing that is delegated to a U.S. magistrate. And some courts, once a lawsuit has been filed, will send out a request or a sort of a questionnaire to the parties asking whether they would agree to have certain pretrial type motions heard by a U.S. magistrate, or whether they would insist on the U.S. district judge himself or herself to hear them. Normally, you can get a faster hearing if it's before the magistrate, but again, that practice varies from court to court. Okay, so after you've gotten your motion filed and you've dealt with the issue of a hearing, if a hearing is to take place, well, then you have to serve a copy of the motion and its attachments and a notice of the hearing date, if there is going to be a hearing, at least 14 calendar days before the hearing date and time. So if there's going to be a hearing, at least 2 weeks ahead of time, you have to serve, that is deliver, a copy of the motion and its attachment and notice of the hearing. Now, there's certain exceptions to this rule, and one is if it's one of those narrow types of motions that can be heard ex parte. That is, when the judge is allowed to consider a particular matter without the other party getting notice of the hearing or being present. This is called an ex parte hearing because it's simply by one party. The other party is not there, such as applications for temporary restraining orders are normally granted ex parte before the defendant has even been given notice of the lawsuit, because they're afraid once the defendant gets notice of the lawsuit, the defendant will do things that will prejudice the plaintiff, and so they want the restraining order issued immediately. So that would be an example of where the party would not have to give 14 calendar days notice. Now, sometimes, though, the rules will set a different time or different minimum time period that the other side has a right to receive notice of. So, or the court itself can order that the notice period be different from 14 calendar days. Now, the 14 calendar day requirement applies to serving the other side with the motion and any attachments to it. And this is if there's an oral hearing. Now, one other deadline that applies is, what about affidavits? There's a special rule for affidavits that support the motion. In this case, the moving party would have to serve a copy of any affidavits the moving party wants to rely on at least 7 calendar days. So The opposing party is entitled to 14 days notice of both the copy of the motion and the attachments and the hearing date, but only 7 days for the actual affidavits that the moving party intends to rely on. So notice that response there. Okay, now let's look at what happens if your client is on the receiving end of a motion. That is, your client is the non-movement. Now, when that happens, the non-movement has some basic options. The first option is to, of course, oppose the motion and file a response in opposition. And that would normally follow the basic format of the memorandum of law portion of the motion that the movement filed, only instead it would argue that the motion should be denied, and it would cite law and maybe even attach evidence to support that position. Now, the deadline for filing a response in opposition to a motion will depend on the local rules. In the Northern District of Texas, for example, a response in opposition to a motion and a brief in support of the response have to be filed no later than 21 days after the motion was filed. And you need to be very careful about adhering to that, because if 21 days has passed and no response in opposition has been filed, the court may treat the motion as unopposed and grant it on that basis alone. So the best practice is, if your client opposes a motion, file a timely response in opposition and any supporting brief and evidence that are necessary to support that response. Because depending on the local rules, the court may automatically treat it as if your client does not oppose that motion if no such response is filed on a timely basis. Now, another option is you may receive a motion from another party in the case where you don't oppose it. Now, if the non-movement does not oppose the relief requested in the motion, then the attorney for the non-movement may simply contact the movement's attorney and say, look, we don't oppose this. Go ahead and withdraw your motion. We'll agree to whatever it is the moving party is asking for. Another option is, in some, depending on local rules, some non-movements will have to file a statement of non-opposition to the motion, in which case the court would grant the motion because it is unopposed. Now, if you're in a court where failing to simply file a response at all will be treated as a de facto statement of non-opposition, then you need to file you need to be careful about that. But one thing you can do when you do not oppose the motion is simply file a statement saying we don't oppose it, and that notifies the court that it can likely just go ahead and grant the relief. And finally, another option when the non-movement does not oppose the motion is to work on the wording of a proposed agreed order, sometimes called a consent order. And if both attorneys for both parties can agree on the wording of an agreed or consent order, then they'll both sign off on it as approved and then submit it to the court and ask the court to sign it. Courts usually will sign orders that have been agreed to by all the parties, but not always. I've been in a situation where a judge would refuse to sign an agreed order. But normally, when the parties are all in agreement with a particular request for relief, with the exception of postponing trial dates, which sometimes judges are a little bit hesitant to do, usually courts will grant and sign the agreed orders. Now, after the non-movement has filed a response in opposition to the motion, the original movement, after having received it, does have the option of filing essentially what's a rebuttal to the response. And that's, in technical terms, in motion practice, called the reply. So the reply is the movement's rebuttal to the non-movement's response in opposition to the motion. And then if the non-movement wants to file a rebuttal to the movement's reply, the non-movement can then file a sur reply. Now, as a practical matter, local rules will frequently provide deadlines for when a reply or sur reply can be filed. But because that can actually go back and forth ad infinitum, local rules usually will provide that after the non-movement has filed his or her response in opposition to the motion, even though the parties may thereafter, if they want, file replies and surreplies, the court is allowed to go ahead and rule on the motion once the original response in opposition has been filed. So that way courts can just shut off the continuing back and forth once it has received the defendant's original response in opposition. And here's an example from the Eastern District, Local Rule 7V, CV7, subsection F. It says that the reply brief responding to the issues raised in the response, if the movement wants to file one, must be filed within 7 days from the date the response is served. And then any sur reply responding to any issues raised in the reply may be served and filed within 7 days from the date the reply is served. However, as you can see, the last sentence says the court need not wait for the reply or sur reply before ruling on the motion, and that without leave of court, no further submissions on the court or from the court are allowed. Okay, well, let's say all of the responses and replies and sur replies have been filed. Now, and if there was an oral hearing, that's taken place. Now the judge will rule on the motion. And again, the ruling on the motion is called an order. There's a couple of different types of orders. The most common type is the written order. And it's obviously an order that is typed out on paper and signed by the judge. But orders on motions can also be oral. And an oral ruling, if made in open court during a hearing or trial, and if it is transcribed by the court reporter as part of the transcript of the proceedings, could be used as a basis for appeal, because there's a formal record of the judge's ruling, even though there was never a separate paper document called an order signed. Unless the order is made in this way, that is in open court during a hearing or trial and transcribed by the court reporter, then the parties must secure a written order reflecting the judge's ruling and bearing the judge's signature. Otherwise, you will not be able to rely on that ruling as a basis for appeal. Now, another type of order that is possible in federal court is called a minute entry. Now, minute entries are notes in the clerk's minutes of the court's ruling at a hearing. These are notes the clerk makes that reflect what happened at a particular hearing. And the clerk makes these notes that become part of the clerk's minutes. Now, clerk's minutes can constitute official orders of the court and can be the basis of an appeal if the minute states that the ruling is an order and it is mailed to the counsel, that is the lawyers for the parties, and it is signed by the clerk who prepared those minutes. So if it states that it's an order, the minutes are mailed to the counsel and the minutes are signed by the clerk who prepared the minutes. And finally, that ruling is entered on the docket sheet of the case, then it does officially constitute a court order that can form the basis of appeal. The docket sheet is in the old days, it was simply a fairly kind of a thin cardboard type material like a file folder would be made out of. And it had lines on it, and where the judge, during the hearing on the spot, would make a note of the date of the hearing and then make notes of the judge's ruling and any other directives the court made during the hearing. And then the next time something happened, in the very next space below it, they'd fill in the information for that next hearing. That's called the docket sheet. Many courts now, instead of keeping these docket entries on paper or cardboard, will simply enter them in the computer. So they can be pulled up and they're computer entries instead of on paper. But either way, that's what is meant by the docket sheet for purposes of minute entries. Now, the form of an order that is written will have certain basic characteristics. As usual, there's got to be a caption at the top. The lawsuit caption has to be at the top. And then the title of the order will normally be Order on, and then whatever the title of the motion was, such as Order on Motion to Extend Time to Mediate. Now, below that, in the body of the order, the court will normally indicate whether or not it held a hearing on the motion. And if it held a hearing, sometimes the court will indicate that counsel for both plaintiff and defendant appeared in person. Sometimes that's noted, sometimes it's not. And then, of course, the body will also contain or describe how the judge disposed of the motion. That is, did the judge grant the motion, that is, agree that it was valid and sign the order granting the relief requested by the movement, or did the judge deny the motion? Or sometimes, especially if a motion has multiple parts to it, a judge may grant part and deny part. And then if there are any additional specifics of the court's ruling, then those can be inserted in the order as well. Now, there may be certain types of motions that the prevailing party, because they prevailed, would be entitled to receive attorney fees incurred in prosecuting the motion, or other court costs such as filing fees, depending on whether there's a rule or statute that specifically allows that. And so if so, the order may provide for that prevailing party to recover the attorney fees in a certain dollar amount, or recoverable court costs in a certain dollar amount. So again, that will just depend on the type of motion it is and whether the governing rule or statute would permit that kind of recovery. Now, after the body of the order, which is the substance of it, then you'll need to have a date line in blank for the judge to fill in to indicate when the judge signed the order. And so you want to leave it blank, because sometimes, even if you have a hearing, the judge may, after the hearing, say, I will take this under advisement, and won't wind up ruling until days later. And so you'll want to leave it in blank. And the common way to do that is simply to say signed on, and then leave a blank for the month, and then a blank for the year. And then below that, you need a signature line for the judge to sign. Now, in federal district courts, the traditional way to do that is to have a line with the judge to sign. It's normally kind of centered on the page, and then directly underneath it, in all capital letters, U.S. District Judge. And then the judge will just sign on the line. Now, in addition, whichever attorney has submitted this order, this proposed order for the judge to consider, if the judge decides to sign one that a party has submitted, the attorney who submitted the order will frequently, at the bottom of the order or at the very end, have a little signature block for that attorney to sign and be identified as the attorney for the party who is seeking this particular order to be entered. So that way the judge knows that this is the order that, for example, the attorney for the plaintiff, Buford T. Justice, was seeking in connection with this motion. Now, sometimes judges do not sign the actual order submitted by either party, but may use their own and craft their own. So in that case, sometimes the judge just drafts his or her own order, signs it, and then sends copies to the clerk will send copies to the parties. So here's an example of an order. Again, at the very top, you have the caption of the lawsuit, as always, and then the title is Order on Plaintiff's Motion to Extend Time to Mediate. And orders frequently can be very short. It depends on the nature. Sometimes they can be long, sometimes they can be short. Here it's very short. It says, after considering Plaintiff Buford T. Justice's motion to extend time to mediate and defendant's response, and after a hearing, we'll just assume the court decided to have a hearing on this, the court finds that cause exists to extend the time for the parties to mediate. Therefore, the court grants the motion to extend time until June 30th, 2017. The verb finds here is a finding of fact that the judge is making based on the evidence that was presented by the parties at the hearing or in the filing. So whenever the judge finds a fact, normally you capitalize that verb to highlight it. Then the word grants is another important verb because that is showing what the court's disposition of the motion is. The court can either grant it or deny it. And so here the court's granting it. And so you would normally want to put in all capital letters the verb showing the actual disposition of the motion. And here is that it grants the motion and to extend time until June 30th, 2017. And then here you have the signature, the date line for the judge to fill in. You have the signature line for the judge to sign. And then you have the line bearing that would have borne the signature of the attorney who submitted this proposed order for the judge's signature, and that would be the attorney for the plaintiff. So that wraps up our basic overview of motions generally. In the next lecture, we will look at some very specific types of motions that are most commonly encountered in federal practice, and I look forward to seeing you then. Thank you for listening.